hitting on a house, and they were supposed to tell us last night.
Yeah, we appreciate it. Thanks for saying that about. Thanks for saying that.
Right
I'll break.
Austin Lake, which is in.
I thought it was 12 hours on West.
Oh yeah, right across the street. Yep.
That'll
West is
restart
nice.
just one
It's just
time.
West is more like Fisher, where I south in Three Rivers. Austin, I like because it's big, shallow.
You still got the channel.
Well, we looked at. I looked right into the next house. I'm gonna pay. I only have like. I don't want to pay. So that's harder to find because everybody just wants to sell you their like tiny cottage.
Right.
Okay.
Where-
Yeah. Yeah,
it's
that's funny.
Where I grew up. Well, I thought it was 12.
Well, yeah. Back then you should have kept it. Now it's like. Oh, here it comes.
Normally, once we open up the browser again, it should
I
be
did not
okay.
have to do that.
You didn't have to do
No,
that once you restarted.
It just booted and connected.
Oh, okay.
You can change that. You have to log in on the statement.
Thank you.
Mm-hmm.
People. Yeah.
Got locked out of my. Access it. I can't even get through. Yeah.
Oh, you can't get on it with your
This is not letting.
So you have to put your name up there, and then that goes in the password, I think.
Your email address.
Oh, yeah. It'll probably be Picard.
It's the
Picard.
Picard the
Yeah. Just put the Picard.
Yeah, and that's what did not work for me.
Yeah, and then that password.
Got room for it,
Denied me.
you know? Yeah, that's the other.
Yeah, so
There you go.
you're-
I'm getting in.
that one didn't work, and then they changed it to 456, and that didn't work either.
If you have your laptop.
I gave it to them.
Oh, you did?
Yeah.
Right.
It's still not connected.
All right, let me.
We'll get up, we'll get things I do one sheet.
You were not able to get in at all?
Sure.
I did when I first got it back, and then like.
You know what,
No.
I had the same problem, but she did figure it out for me.
Yeah, so they're looking at it again. Should I have to staple that?
Just grab it.
Okay.
Clear it.
Okay. First got here. It was working when I first came in.
Couple minutes, we'll get started and get the top part.
How far out does it be, Andrew?
It's just like less than 5 minutes from.
Oh, okay. I see. Thank you. Right, that's fine. Okay.
I don't have another one. I already opened this.
Get rid of this stuff.
I should have.
Board will come to order. We have one board member that's not very far away, be here shortly. So we'll welcome everyone today. And would you please clerk do a roll call, members present?
Chairman Rick Johnson,
Here.
David LaMontagne, not present. Vivian Picard,
Here.
Nicole Cover,
Here.
Donald Bailey.
Here.
Chairman Johnson, you have a quorum.
Okay. Number 3, public comment. I just want to remind the public that wishes to speak later in the meeting that, please be careful as to what you say. Do not pertain to any license application. If you have ideas for us, we're more than helpful and grateful to have you present them to us. So keep that in mind, please. We really don't like gaveling anybody down. Number 4, approval of the agenda. We need a motion.
Motion to approve.
There is support.
Support.
It's been moved and supported to approve today's agenda for the August 9th Medical Marijuana Licensing Board. Clerk, please call the roll.
Chairman Rick Johnson,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey.
Yes.
Motion passed.
Okay, thank you. Number 5 is approval of the July 12th, 2018 meeting minutes. Have you had time to go through that? If so, I'm open to a motion.
Motion to approve.
Second.
Okay, it's been moved and seconded to approve the minutes of July 12th. Hearing no discussion, clerk call the roll.
Chairman Rick Johnson,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey.
Yes.
Motion passes.
Thank you. Number 6, old business. Does anyone have any old business they need to wish to discuss, suggest, or whatever? Hearing none, there is no old business. New business, we are going to pause for a couple minutes. I believe our fifth board member should be walking in at any moment. So anyone needs, break or that, now's the time to take it.
Have my notes. You just rolled with it, right? Hi.
I need glasses because I read so much between the two boards that
Oh.
I start like, I'm on the top line and I'm reading.
So which one keeps you busiest?
I have more to read, probably, but
Okay.
like on one of the sheets, so
Mhm.
I just have
So it's easier, you
yeah,
know.
this one I,
Mhm.
yeah,
Mhm.
yep.
Do you want to solve it? I don't. So it's not now you should
Walking in or closed, because he hasn't answered my text. Okay, no matter to me.
This one. Am I? Or, you know what I mean? Like if.
Right. I understand. Thank you.
Okay. We're ready for, start new business at number 7. And just a reminder, as we move through these, some board members, that when you're making your motions, please refer to what we want to do, whether it's approval, denial. I know we're all getting kind of used to it, but just to. Okay, we're going to go to A, which is pre-qualification. Applicant number 1 is DNVK Lapeer, Inc. Open for discussion and action by the board.
Mr. Chairman, I move that DNVK Lapeer, Inc. has pre-qualification status for a pending application. Second.
Okay, it's been moved and supported to pre-qualify DNVK Lapeer, Inc. Discussion by the board. Any questions for Chris? Okay. Clerk, call roll.
David LaMontagne?
What?
Yes.
Yes.
Yes or no?
Yes.
Vivian Picard?
Yes.
Nicole Cover?
Yes.
Donald Bailey?
Yes.
Chairman Rick Johnson?
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Okay, number 2, applicant is Harbor Farms North LLC. Board wishes on this? Comments?
Mr. Chair, I would move to deny Harbor Farms North LLC, and we'll make the specifics once we have the discussion as far as the criteria for the denial.
I'll second that.
Okay, it's been moved and supported to deny number 2, Harbor Farms North. Board discussion. Question?
Oh, I'm sorry.
Yeah.
I was reading.
Failure to report.
I was reading my notes. There's a failure to report some marijuana delivery from some time ago. That was not reported. There were 3 attempts, it appears, 2 attempts to clear that up on the application, and neither contains the arrest. First, it was left blank. And the second time around, when they gave him an opportunity to correct the record, he said no. That was to the applicant KR. As far as the applicant MI, it was a 3rd time around that he disclosed an arrest on that applicant. It took 3 times to get that application disclosed.
What else? Okay, remember the motion is to deny, which takes a yes vote if you're going that way. No further discussion.
We'll need
To,
us.
Put into the motion
Oh.
the reason why though, because
Oh,
we're
yes,
gonna
that's
do
right.
that after
Yep.
discussion.
402-2C, the applicant knowingly submitted a license application containing false information. And 402-3A, the integrity, moral character, and reputation of the applicant, KR. The failure to identify the marijuana delivery arrest.
After having an opportunity. So we can detail out the.
Get that, Kelly?
Yep.
Okay. All right, go ahead and call the roll.
David Lamontagne,
Yes.
Vivian Picard,
Yes.
Cole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Okay, number 3. Q. Pardon? Oh, okay. Number 3, QPS Michigan Holdings. The direction from the board.
Mr. Chairman, I make a motion that QPS Michigan Holdings has pre-qualification status for a pending application.
There's support.
Second.
There is support. Been supported and seconded to approve applicant number 3, QPS Michigan Holdings. Is there discussion from board members? If not, we will call a roll.
Is this the most supplemental we've ever had
Yeah, I believe so.
so far? Holy cow. I mean,
Yeah, thanks.
I needed like a new prescription for my glasses. A lot of people involved.
David Lamontagne,
Yes.
Vivian Picard,
No.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 4 yeses, 1 no. Motion passes.
Number 4, the applicant is Amazing Buds LLC. Is there any activity from the board?
Mr. Chairman, I move to approve Amazing Buds LLC, that they have pre-qualified status for a pending application.
Second.
It's been moved and seconded to approve Amazing Buds for pre-qualification. Open for discussion. If not, clerk, call the roll.
David Lamontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Number 5, MEM Gardens LLC. For pre-qualification, is there a motion?
Mr. Chairman, I would move that MEM Gardens LLC has pre-qualification status for a pending application.
Is there support?
Second.
It's moved and supported to grant MEM Gardens pre-qualification discussion. Hearing none, go ahead and call the roll, clerk.
David Lamontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Okay, number 6, Green Labs LLC for pre-qualification. Is there a motion?
Mr. Chairman, I move that Green Labs has pre-qualification status for a pending application.
Is there support?
Second.
Been moved and supported to pre-qualify Green Labs. Discussion by the board?
Mr. Chairman, regarding Green Labs, two issues. One with, or a couple with each applicant, it would appear. Reference applicant LI. He's a caregiver. He makes a significant profit from his caregiver business, which is not consistent with the 2008 Act. There's monthly electric bills that do show that it's likely a fairly substantial home caregiver operation. In explaining the money that he's making from that, he's claiming in his application that he's only making, or he's only harvesting 2 or 3 ounces per plant times 72 plants. That's not consistent with what we know from law enforcement as far as what they're getting from these plants and these grows. In regarding to applicant BL, there's 2 undisclosed arrests from 98 and 2000. When asked to give an explanation on that, he said he thought the form only required drug convictions. In looking at the plain wording on the form, it was very clear that it to be disclosed.
Anything else, anyone? Motion is to approve. I'll have the discussion. Clerk, call the roll.
David LaMontagne,
Gonna abstain.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
No.
Chairman Rick Johnson.
No.
Chairman Johnson, you have 2 yeses, 2 nos, motion fails.
The board may wish to discuss further and see if you can, with additional discussion, try to vote again and see if you can pass a motion.
Any other motion up that anyone wishes to provide?
I would make a motion to deny. Green Labs LLC. Section 402(2)C, knowingly submitted a license application containing false information.
Maybe Chris,
Is there
somebody from
I'll support it if you want to get
for
that.
discussion. Yeah. Okay.
Go ahead, Nicole.
So for discussion purposes, we look at when they're filling out the application and they say, I didn't think that needed to be disclosed. Can we create some sort of consistency? Because I do think that they're interpreting it as it relates to what they're going to do, if it's domestic violence or if it's a moving traffic violation without being under the influence. I think we've had that come up in the past. So I would just encourage us to be consistent in however we approach that. I think if we can establish that early on as we're doing pre-qualification, it's going to be much easier to move forward. I'm not as concerned about a non-drug arrest, but that is, I just want to make sure that we're consistent with that because I feel like I don't know if there's a way that we can get that, but whatever the approach is, it needs to be consistent so that we're sending that message to the applicant so that they understand moving forward.
I agree with Nicole that we should be consistent and also that we stick to the facts of what's presented to us as well.
Because it's a slippery slope if you start making assumptions. Learn that in all walks of life. The first thing I tell my kids is never make an assumption. Not that you're all my kids, but I'm just saying. I think we look at what we have, we make a decision, this is pre-qualification. As they move forward, if there's something that continues to be a concern to the department, then that's a different story.
And it would probably be helpful in the director's report if you indicate on there that the disclosure was not, I know you're indicating currently, but maybe you want to say, even after a second time, it was not, so it's very, very clear at the end of the checks as to what we're dealing with. So we all understand the same thing.
If I don't, is this working? Yeah, okay. If I could just speak to that, because that is one thing that we've looked at and where we are seeing some consistency in failures to disclose are traffic offenses. People say they don't believe that they have to be identified, and then juvenile offenses. And with regard to the traffic offenses, there's a disconnect between the statute and well, disconnect's probably not the right word for it, but there is a difference between what the statute allows the board to consider as far as criminal history. It allows everything but traffic violations. And then we have the failure to disclose. And the form says, have you ever, all of these things for a misdemeanor or a felony. And I think there's great confusion when it comes to traffic offenses, because there are traffic offenses that are misdemeanors or felonies. According to the form, they are supposed to be disclosed, but people, they're combining the statute with the form, and they're making their own beliefs or assumptions that they don't have to disclose those. Same way with juvenile records. Attorneys systematically are telling people you don't have to disclose those. However, on the form, it says, have you ever had a charge expunged? So clearly that would mean juvenile. So that's what we're consistently seeing.
And you are consistent with saying as to whether or not it needs to be disclosed. I appreciate that, but I think it would be helpful to us to just be very clear to say after the second request, it still was not disclosed, or it was clearly not disclosed. So we're all on the same page.
Right, especially if we're going back to the applicant saying, okay, we have a different story. And because if you give them an opportunity and they correct it, then I don't think we can hold that against them. But if it's been 2, 3, 4 times and we're getting it back and they're still saying no, then.
Especially if the reason for not disclosing it is a real legitimate reason. But maybe there's, well, on the application, I think it is pretty clear, but maybe it should be bold with something, I don't know. But if everyone can help us get the message out that these disclosures are really, really important. And I think we continue to say that at each one of our board meetings, that we need to really get the message out, that disclosing anything is very important. You're not going to be penalized for as much for disclosing it as it is for not. It will come up. Even I think if you were 3 or 4 and did it, so.
More discussion.
In the present case that we're talking about in regarding the applicant BL, it was not a traffic offense that we.
No, it wasn't. Not on that
Right.
That wasn't talked about, even though we've been talking about that right now.
Yep. Domestic violence.
And that, when I read the question, it's pretty serious business to be filling out this application if you're trying to get in this business. So you need to be very careful whether it's an attorney doing it for you or you're filling it out yourself. They do sign an attestation that information is true and correct. It is the applicant's responsibility at the end of the day. And that question is pretty clear. Convicted of any felony or misdemeanor, any jurisdiction, and all those were checked no.
Else? The motion is to deny. Go ahead and call the roll, clerk.
The denial motion is under 402(2)(c), is that correct?
Yes.
David Lamontagne,
I think with some necessity for clarity, I'm just going to recuse myself. Personal beliefs that I do some work in this town. I don't know these people. I don't know anything about it, but I think it's safer and cleaner. So,
Vivian Picard,
No.
Nicole Cover,
No.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 2 yeses and 2 nos. Motion fails.
What's the feeling of the board here? Any other suggestions or? You have a failure to disclose, kind of what we just talked about in that area. So,
I would suggest we move to the next one.
Need to make a decision. The board can perhaps discuss a little bit more, attempt one more vote to try to have an action one way or the other. Keeping in mind, a denial gives the applicant an opportunity for a hearing to establish their suitability and eligibility for a license.
we need a motion then. Try another vote, we need a motion.
Mr. Chairman, I move that Green Labs has pre-qualification status for pending application.
Their support.
Yes.
Moved and supported to approve Green Labs for pre-qualification. Discussion.
So in this failure to disclose, which I think was domestic violence. So there was no, applicant never came back. This was just what we found. I just want to make sure we're clear.
We always ask the applicant to explain why there's a non-disclosure, and there was an explanation in the materials that I can pull
Can you
up.
read that?
Yeah.
Sorry, there's a lot of material. I didn't specify.
And I don't have it with me.
Chris, this is just for pre-qualification,
Correct.
Absolutely.
and so then they're gonna have to come back phase 2.
Yes.
Okay. Any other comments, questions?
The response, response was, I apologize. And this was under the question was asked about the individual who had the non-disclosure. It was asked to the person managing the file, the other applicant, and that's the other applicant is answering this question. And he says, I apologize. I was under the impression that the disclosure was only related to felonies or marijuana-related offenses. I will update this disclosure and come back to you with a full explanation.
And I think that goes to kind of the process of how we're getting through background investigations is if somebody wants to know what I did or said, they need to ask me what I did or said. We're going through attorneys in many cases, and I understand their purpose in doing that. But these questions need to be posed of the person who has the information that we're trying to get. And so now we're trying to make assumptions based on what somebody said. That's not admissible in court for a good reason. We don't know if that's the information that's correct or not. It's what was said, but we don't know. And if we would have gone out and had that face-to-face conversation, then we would know and we would be able to say that. Because now, just as you pointed out, this is what somebody said he said.
If the first request for to explain it was directly with the applicant, it probably would have been
Correct.
Disclosed initially.
Well, once we have told them we found something, them filling out the form in a correct manner is not a disclosure on their part. The department doesn't look at that as a disclosure. Disclosure, for us, a disclosure is they come forward without prompting or being told that there's a missing charge, that's the way we look at it when we fill out the paperwork for you. Certainly, it's the board's decision as to what really is non-disclosure.
Right.
But when we look at it, we're looking for them to come to us at some point in the investigation and give that information before we go back to them and ask them about something we found.
Looking at the response, and again, it's not with the applicant who
Had the offense.
had the offense, but it says, you know, it was an apology under the impression the disclosure only related to felonies or marijuana, but then you go to the question, it says any. So I don't see how you make that determination as it's explained in follow-up explanation that it was only about drugs. Well, the question clearly, to me, any felony or a misdemeanor under the laws of any jurisdiction. It seems clear to me.
Well, this is going to be the last vote because I'm going to break the stalemate one way or the other here. Spent enough time on this one. No further discussion. Clerk, call the roll.
David Lamontagne. Vivian Picard,
Yes.
Nicole Cover,
No.
Donald Bailey,
No.
Chairman Rick Johnson.
No.
Chairman Johnson, you have 1 yes, 3 noes. Motion fails.
So do we need to do a denial motion?
We'll need to do a new motion to have an affirmative vote on that.
Someone wish to make that motion?
Mr. Chairman, I move that the applicant's ineligible for, and this is regarding applicant BL, section 4022C, applicant knowingly submitted a license application containing false information.
There's support?
Second.
Been moved and supported to deny Green Labs LLC. No more discussion. Remember, this is a yes vote to deny. Clerk, call the roll.
Vivian Picard,
No.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
And Lamontagne
Recused himself.
Okay, number 7, Ann Arbor Provisioning Center.
Mr. Chairman, I move that Ann Arbor Provisioning Center has pre-qualification status for pending application. Second.
Been moved and supported to pre-qualify Ann Arbor Provisioning Center LLC. Any board discussion here? Hearing none, clerk, call the roll.
David Lamontagne,
No.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
No.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 3 yeses, 2 noes. Motion passes.
Number 8, TCMI AZ LLC. Bit different. Is there a motion to deal with this one? For pre-qualification?
If I could point out, Mr. Chairman, this is the same applicant that was
Right.
just pre-qualified as Ann Arbor First.
Any discussion?
Do we have a motion?
No. No. We need a motion. Something up they did discuss it.
Mr. Chairman, I make a motion, I don't know how we go about this now, we just approved one, but I would move to deny TCMI, since no one's moving to, for an approval. Under 402, 4023A, the integrity, moral character, reputation of the applicant in regards to the operation that he has going and has been for several years.
Your support,
Support.
discussion. Discussion?
Oh, I'm sorry, Mr. Chairman. Regarding, it's actually I believe there's four licenses. My comments are the same on all of them because they're all related. This is a provisioning center that has been operating. Showed in 2017 a net profit of over $1 million. Showed gross sales of $4.5 million. And as I have pointed out, as some others have pointed out, a CPA from the industry, there's tax evasion, there's money laundering, sales tax hasn't been paid. In 2017, based on the numbers provided in the application, there's $280,000 in sales tax that was not collected because none of that was being collected. Obviously, at that point, they were stepping way outside the bounds of the 2008 law. There's certainly discussion on whether somebody can recoup their money for their time in this business. The law looks clear when you read it plainly from 2008 that you can't make a profit. And another question becomes, can you recover costs for your time? There's discussion both sides on that. In the Redden case and in opinion that was a concurring opinion that was addressed. I just think for all those businesses getting into the business now, they're at a distinct disadvantage by us approving and allowing something that's been illegal under the 2008 law to get into the 2016 Act.
Can I clarify for the record? I believe Ann Arbor Provisioning is the provisioning center, and that has been approved, correct?
Right.
Because
This
the
is a-
motion on the
this is a
floor
grow.
is, the motion on the floor is for the grower Class C.
Right.
So there's
There-
no sales tax for a grower Class C. They're not temporarily
Oh, right,
operating.
right. Yeah, you're right.
Just want to make sure everybody's clear on which one we're on.
Right. Chairman Johnson got ahead of me on the last one before I could speak up.
But I
That
still,
would be my objection on this package of licenses.
but I still think we need to stick to the facts of what's presented to us. And secondly, if there was something illegally that was going on, hopefully when the law enforcement team reviewed the application, hopefully if they realized that there was something inappropriate, that they would submit it to the appropriate authority.
The state police.
I don't think we can make a lot of assumptions. Again, if they were doing something illegally based on the 2008 law, then I don't think that's our responsibility to do anything. I think that's, if the law enforcement team looked at it and if they saw something that was illegal, then hopefully they will present it or has presented it to the authority.
That's another part of the problem. The money that goes into these other three licenses was loaned from the provisioning center. And so all that money is money really from a continuing criminal enterprises to fund the capitalization on these other licenses.
But still, if it's truly a criminal enterprise, I don't think that's our decision. That's the decision of the appropriate authorities to make that decision, to say that it was a criminal enterprise.
Right. And from what I know, and again, it's just based on my experience, that is what's going on with these places. And the criminal justice system is multifaceted. You have the police, obviously, who do the investigations, but then you have prosecutors who, if you don't have the prosecutor on board, you have an investigation that's going nowhere. And that's what's happened in some of these counties. We have 83 counties in the state. 79 counties are pretty much in lockstep in enforcing the law. There are 4 counties, Washtenaw County being one of them, that have not enforced the 2008 law as regards to these dispensaries. And that's why we find ourselves in this position.
But I don't think that's our responsibility as a board.
I think it is, but that's,
This is phase one.
Mhm.
Right? Yeah, can I see it is on the.
We have a motion to deny under section 402(3)(a).
Call the roll?
David Lamontagne,
Yes.
Vivian Picard,
No,
Nicole Cover,
Yes.
Donald Bailey,
yes.
Chairman Rick Johnson.
No.
Chairman Johnson, you have 3 yeses, 2 noes. Motion passes.
Okay, next one is TCMI Manufacturing. Excuse me. Is that right? Yeah, I got the wrong one. TC Ann Arbor Manufacturing LLC.
Chairman Johnson, I would make a motion to deny based on the same facts that we had just talked about for TCMI Ag.
Support.
Moved and supported to deny TMI Manufacturing. Discussion. Everyone's clear, this is for processing. No discussion?
And just to be clear, what is the provision? Same provision as the last time?
Yes, 402 3A, the integrity, moral character, reputation. And really G, it's the history of non-compliance with the regulatory requirements in Michigan or another jurisdiction. Certainly not following the law for me in this respect is the non-compliance with the regulatory rules.
Okay, the motion is to deny. Clerk, call the roll.
David Lamontagne,
Yes.
Vivian Picard,
yes,
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Okay, number 10, TCMI Ann Arbor 2. For a non-operating provisioning center.
Mr. Chairman, I make a motion to deny, and it's the same discussion for the other applications here. This was funded through the Ann Arbor Provisioning Center, that money, and that would be section 402 3A, integrity, moral character, reputation, and G, the history of non-compliance with regulatory requirements.
There's support.
Support, but I just want to kind of make a clarification.
Ed, you have
So I'm not sure I agree with the G. I think everybody's
I
probably,
think G is for, correct me if I'm wrong, more like current standards. If somebody went there, if we offered a cease and desist and they didn't follow, or I don't know
well,
that we
yeah,
can
I just think it's clear that what Mr. Bailey's position is on
Right.
people that are operating now, and I just disagree with it,
Right.
that piece of this thing. But the denial on the first statute is the one that resonates with me, so just for clarification purposes.
and she was not identified either. in the background check.
Sorry, what was that?
She was not
Oh, G.
identified as
Letter
issue in
G.
the background check.
Oh.
So I agree with David. So
We'd have to amend the motion if we're going to vote.
Correct. Right now, we have a motion to deny under 402(3)A and 3G. That's the
We're asking
current
you to
motion.
take
If you want to amend, you can do so.
So
Is
to,
there a friendly,
so to amend my motion to read simply 4023A, integrity, moral character, reputation of the applicant.
Have a friendly amendment. The denial is only under 3A.
Yep.
And Mr. Lamontagne, do you agree with that? You
do.
seconded?
I do.
okay. Clerk, call the roll?
David LaMontagne,
It's a yes or no?
To deny,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Number 11, Natural Caregivers LLC.
Mr. Chairman, before we move on to that one, the very first one, and maybe this is a question for the Attorney General. Can we revisit at this point the provisioning center? We passed it. And this was a package of applications that are all tied together. Is there a chance that we can revisit that now?
I'm prepared to revisit it when it comes up for
Okay.
phase
It's
2.
just pre-qualification.
Okay.
what we would need would be a motion to reconsider by somebody who was on the prevailing side. In other words, in that situation, somebody who voted yes to approve
Okay.
would need to move to reconsider.
We're just going to move on.
The only concern I have with that, and just for discussion, so it's out there, knowing the way these others went, if we allow them to go forward, he's going to be investing, this applicant's going to be investing a lot more money. And do we owe it to him to not, to let him know today that the likely outcome would be maybe you don't invest all that more money now? That's my only concern is there's going to be a lot more investment going on.
Not my concern, actually. That's what I look at it. Wrong.
Oh, yeah, I just throw that out there because you hate to put them in a position where they're continue to invest, knowing what's happened with the other applications.
Okay, number 11, Natural Caregivers LLC. Direction from the board.
Mr. Chairman, I move that Natural Caregivers has pre-qualification status for a pending application.
Second.
Been moved and supported to approve Natural Caregivers. Discussion?
Mr. Chairman, this also falls back into a number of undisclosed arrests regarding applicant TS. There was another delivery of marijuana from 2013. Not arrested. It was not disclosed. I'm sorry, it was not disclosed on the first application. That was before the form was before and after the form was changed. And this application was submitted in March, and it was finally disclosed after he was confronted by the state police in an interview in May. We continue to get a lot of information back, and this is regarding financials on the same applicant, TS. It just don't make sense. When we talk about there was a particular deposit, and the LARA analyst asked for the question, what was the source of that deposit? And instead of answering that question, which was a pretty simple question, the applicant responds on what he spent the money on. I think he's trying to get around what is actually going on here, which is common in a business that wasn't legal at this time.
Motion is to approve. Any more discussion?
Can I clarify on the marijuana charge? That was disclosed. There was another non-disclosure, but the marijuana charge was disclosed.
Did I write that down wrong?
We have a disorderly person
I have it too.
in 99 and in 97, a receiving and concealing stolen property that wasn't initially disclosed, but the marijuana charge was disclosed. I just
Okay.
wanted to be clear on the record.
Thank you.
Okay, any other discussion? Motion is to approve. Call the roll?
David Lamontagne,
No.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
No.
Chairman Rick Johnson.
No.
Chairman Johnson, you have 2 yeses, 3 nos. Motion fails.
Okay, we need a motion to deal with this. Yes,
Mr. Chairman, I move we deny the applicant National Caregivers LLC, Section 4023A, integrity, moral character, reputation, and the 4022C, the applicant knowingly submitted a license application containing false information.
there's support. I'll support it. Any discussion? More discussion? Not clerk, call the roll?
David Lamontagne,
Yes.
Vivian Picard,
No.
Nicole Cover,
No.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 3 yeses, 2 nos. Motion passes.
Number 12, Superior Cannabis Solutions.
Mr. Chairman. Yep. I move to deny Superior Cannabis application because the applicant is not qualified to receive a license. His Licensing Act 402. Sorry? 3A and G.
Second.
And for 3A, can you narrow it down to the more specific? Is this again integrity, moral character, and reputation, or one of the other subcategories?
It's an integrity issue.
Okay, any more discussion?
Yes.
The motion is to deny.
Mr. Chairman, for the sake of the record, I think we probably do need to talk about it a little bit. This is a temporary operator without local attestation, operating defiantly. The police, and maybe it was Laura, issued a cease and desist. And so they closed the operation and moved it simply to another location and changed the name. They continued to operate again. The drug team in this area has made 5 separate buys into the illegally operating dispensary.
Yeah, I don't think we need all that detail, but I think we do need to understand that we had a department that issued a cease and desist and they didn't follow it. And that is a huge integrity issue
Right.
for me, like play the game, move along. And then when they do show up and you don't allow them into your facility, that's another red flag. So like there's reevaluate that they are not running the UP and get their integrity and figure out how they're going to do things differently. Very alarming pre-qualification.
I agree with Nicole.
Okay, let's go ahead and call the roll. The motion is to deny.
David Lamontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Number 13, Live Well Michigan LLC, DBA Live Well Enlightened Health. Direction from the board?
Mr. Chairman, I move that Live Well Michigan has pre-qualification status for a pending application.
Second.
Moved and supported to approve pre-qual for Live Well Michigan. Discussion by the board. Clerk, call the roll.
David LaMontagne.
Yes.
Vivian Picard.
Yes.
Nicole Cover.
Yes.
Donald Bailey.
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Okay, number 14, pre-qualification applicant is Holistic Research Group. Feelings of the board?
Mr. Chairman, I would move to deny Holistic Research Group Incorporated regarding an application, an applicant JB 4022C. The applicant knowingly submitted a license application containing false information.
Board.
Okay, it's moved and supported to deny applicant Holistic Research Group. Discussion.
Mr. Chairman, this is regarding another arrest, and Chrissy's hopefully got the file up because these are my notes, but this is another PWID, possession with intent to deliver marijuana arrest that was undisclosed. Based off of that charge, there were half a dozen probation violations. There was another arrest by the DEA in 2011. That was a possession with intent to deliver marijuana case.
Any more discussion? Not, the motion is to deny. Get the number.
And that's under 4022C.
Okay. Clerk, call the roll.
David LaMontagne.
Yes.
Vivian Picard.
Yes.
Nicole Cover.
Yes.
Donald Bailey.
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Okay, number 15, Great Lakes Natural Remedies. Anything from the board?
Mr. Chairman, I move that Great Lakes Natural Remedies has pre-qualification status for a pending application.
Is there support?
I'll second.
Moved and supported to pre-qualify Great Lakes Natural Remedies. It's open for board discussion. Board discussion. Clerk, call the roll. Is to pre-qualify.
David LaMontagne.
Yes.
Vivian Picard.
Yes.
Nicole Cover.
Yes.
Donald Bailey.
No.
Chairman Rick Johnson.
No.
Chairman Johnson, you have 3 yeses, 2 nos. Motion passes.
Okay, we are on to the complete applications. Number 1, DB Chesaning LLC for a processor license. Is that right?
Correct.
Feelings of the board?
This applicant was pre-qualified in July of this year, so we would need a motion either grant or deny the application.
The operating license? Oh, no,
That's correct for the operating
for
license.
the operating license.
Or processing license.
Mr.
Chairman, go on, John. Go on, John.
Mr. Chairman, I move to grant BB Chesning LLC as application for a processor license.
There's support.
Support.
Support. Discussion. No discussion. The motion is to approve VB Chesning LLC. Clerk, call the roll.
David Lamontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Number 2, applicant is Choice Labs LLC.
Mr. Chairman, I move to grant Choice Labs LLC operating license.
And just to be
As a
clear,
provisioning center.
Choice Labs was also pre-qualified.
For provision and center.
Support.
Moved and supported to approve Choice Labs license, phase 2. Any discussion? Go ahead and call the roll, clerk.
David Lamontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Number 3, Iron Laboratories LLC. This is for a lab, testing lab. I say that only because the last one said lab, but it's really not a lab. Yeah.
Chairman, I'll move to grant Iron Laboratory LLC's application for a safety compliance facility license.
Is there support?
And just to be clear, this applicant has not yet been considered for pre-qualification. So a motion to grant the application also gives the applicant pre-qualification status.
There's support for the motion. I'll support it. Get the discussion here. Discussion by the board on this?
Mr. Chairman, I do have one question. It's probably, or a couple questions are probably for the application section. In the technology plan for the facility license app, Iron Labs mentions that they have a LIMS, a laboratory information management system, but they don't identify which one it is. Do they have one, and does it integrate with Metric?
I believe they do. That Mr. Hannah could probably speak to that more directly.
I understand that based off the knowledge that we have, that they're working to integrate with a third-party integrator. But whether or not that specific system does at this time is unknown. We're still checking with that.
Okay.
As far as their future capability of connecting with Metric, but passing the pre-qualification license inspection, they do pass because the Metric capabilities are unable to take care of that during the inspection process.
Right. It's kind of a related question to the other safety compliance facility that's going to come up. If we don't have if we don't have their software that integrates with Metric, can we give them a license? Because we can't. The system's going to stop right there.
They do have to have a system that integrates with Metric. Iron Labs does have a proprietary system. Their LIMS system is homegrown, but it does integrate with Metric.
Okay.
They use it already, at least in Oregon, to integrate with Metric.
Okay.
So, yes.
All right. That was the question I had. The other question, maybe back to you,
All right.
is the Bureau of Fire Safety report talked about not having a flammable storage cabinet in the processing area, or I guess not processing because they're a safety compliance facility. Is that something we can license without having that in place?
They have,
Do they need that?
they have passed BFS inspection. They have signed off on their inspection as being complete.
Okay. Are we're requiring, or BFS, I guess, would be requiring that this flammable storage cabinet, they have that?
If they have approved them and it's not conditional approval, then no, they would not have to have that. I mean, BFS has approved them as they sit at this time.
Well, I'm confused because when I read their report, they say they'll come back out when that comes in for another inspection.
Question, is it possible for us to approve this on a pre-qualification status as opposed to an operating license?
Well, we may be able to do both, I think, but just not actually issue that license until whatever BFS wanted. And you're saying the technology plan is there because it's a homegrown system they've got. I just don't want to issue the license if they have things that need to be addressed.
And that's why I'm posing this question as to whether or not it's possible for us to move to pre-qualification as opposed to.
This is before you as a complete application for the state operating license, which would include pre-qualification. But what you have before you is for the entire approval for the facility license.
And if I can read from BFS report, it does say that they will come back out when they get the flammable storage cabinet. However, it says, a fire safety inspection was completed on this date. Deficiencies noted in our last inspection have been satisfactorily corrected. So
It sounded like it was a condition that they then did.
But it's not done yet.
Yeah.
So that's my confusion in reading that report when I read it.
They're not, though, ongoing compliance,
That's true.
follow-up inspections, et cetera.
yes, there are.
So that should give us some measure of comfort.
I agree.
The only concern I have, and not to say this is going to happen with this application, but, we're going to approve a license and you're going to do this and we get the okey doke and, 6 months later, it's still not done. I'm not thinking that about this application, but we're going to be faced with those kind of situations.
No, don't disagree with you. I think that's the role of the department. Stay on top of it. I'm busy.
And the other question is whether or not we can table it into the next meeting since it's about a month away. And that way, hopefully, all of these concerns will be addressed.
If there is a failure to comply moving forward, once an applicant or once a license is issued, then you would have the option to take disciplinary action as appropriate if the then licensee fails to do something that they were required to do.
But providing someone is an operating license to me shows that you're ready to go. So my recommendation is that we table it so these things are done. And hopefully, we have a meeting in another month.
I think
when someone approves something, it means that if we're approving it for an operating license, that means my facility is ready to go.
So what you have in front of you is a motion to grant the license for the safety compliance facility. What you need to look at is whether they meet the baseline criteria for licensure based on the information you have in front of you.
Mr. Hanna has gone to call BFS to clarify with them the status, but I do understand there is a motion on the floor. I just want to make you aware of that.
Can we put it out of order? Can we move it to the end?
Can we table that? Yeah, to the end.
For a motion to table it to the end of the meeting?
Motion to table.
End of section B.
Yeah.
Okay, your motion?
Yes, to table it until after precision safety innovation.
Okay.
Second.
Second. All in favor, say aye.
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 Motion carries. It will be moved till after last one, whatever it was you said.
After the number 15, it would, after number 10, I'm sorry. Precision safety innovation.
We had an all in favor. I don't think we heard any opposed.
That's right.
Oh, I'm opposed.
I'm on
You're
team.
opposed? Yeah, table?
I did. Doesn't
Okay.
matter, but I am, for
Okay.
the record.
4-1. Number 4, applicant is Brightmore Gardens LLC.
another one that's both, right?
That's correct.
So again, we would need,
Brightmore has not been,
that's correct. So again, what we would need is a motion to either grant or deny the application, and a motion to grant would include or give the applicant pre-qualification status.
Chairman, I move to grant Brightmore Gardens operating, a state operating license.
okay, motion is to grant. Is there support? I'll support. Motion now for discussion. Brightmore Gardens, is any board member wish to make comments or?
Mr. Chairman, regarding this application, Brightmore Gardens LLC, first applicant WA, there's a felonious assault that from 2006, but he wasn't released from probation on that until 2009. If I could ask Ms. Jordan, the statutory limits on these crimes, when they're released, when they're charged, or when they're released from incarceration, or in this case, probation, that would be timeliness of it.
Would be the conviction date.
The conviction date? So that's, that was January of 7, if we're using the conviction date.
That would be over 10.
Right. Yep. It's the same applicant. There was a domestic the income taxes for this, the same applicant WA shows an income that's at or likely below the poverty line, but we're seeing over $70,000 in money coming in and out of his account. A single deposit for $50,000. It just doesn't make sense to me how that can happen. And regarding the second applicant on this application, BB, there are some rental properties, there are commercial properties. I believe they're all in the city of Detroit. They're 4,000 square foot facilities, and he acknowledges that they're being rented out to caregivers for growing marijuana. A caregiver in Michigan, if you had all your patients, you can grow 72 plants. Well, you don't need 4,000 square feet for that. You do need 4,000 square feet if you're talking about 500 or 1,000 plants, which is likely what's going on here. This is feeding the black market that we're trying so hard to get away from. And I don't think this is someone that I would consider has the integrity for a license.
Any discussion?
We have a motion to grant the state operating license for Brightmore Gardens Provisioning Center, which would also give the applicant pre-qualification status.
More discussion? Clerk, call a roll.
David LaMontagne,
No.
Vivian Picard,
Yes.
Nicole Cover,
No.
Donald Bailey,
No.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 2 yeses, 3 nos. Motion fails.
Okay, feelings of the board, direction. We need a motion to deny.
Mr. Chairman, I make a motion to deny.
Okay, is there support?
We have a statutory,
Section 402. 2C, the applicant knowingly submitted a license application containing false information. And 4023A, the integrity, moral character, and reputation of the applicant.
Okay, is there support?
Support.
Been moved and supported to deny Brightmore Gardens LLC. Any discussion? Clerk, call the roll.
David LaMontagne,
Yes.
Vivian Picard,
No.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
No.
Chairman Johnson, you have 3 yeses, 2 nos, motion passes.
Okay. Next one, number 5, Black Rock Management LLC. This is for just 2, right?
Yes, they're pre-qualified on July 12th.
So we just need a motion to grant or deny the application for the provisioning center.
Chairman, I'll make that motion. Grant Black Rock Management application for provisioning center license.
Okay, the motion is to grant Black Rock Management a license. Is there support?
Second, can I ask a clarifying question? If something changes as far as like anything that is different from the pre-qualification application to the licensure application, is that pointed out or do we have to reference that back?
If we had any information to add to the pre-qualification information, it would have been indicated in your report in blue.
Okay. just-
And there
'cause
was,
this is a new process, so I just want to make
Correct.
sure I didn't miss.
correct,
anything.
there was
Okay.
none, but there could be a certain stance sometime when there would
Gotcha.
be.
Okay.
Any other discussion?
Mr. Chairman, we talked about this when it was up on July 12th. I don't need to go over those same arguments that I made, but what is different in this report that we have now that we didn't have then, there was that raid at his at the building where he operates out of on Dwyer. And he claimed that he didn't know anything about what was going on there, that THC Expo that took him there, that resulted in that Detroit police raid. But I find it kind of hard to believe when they did find out and they added to the report this time was he was advertising that event before it happened. It's kind of hard now to claim, in my mind, it's kind of hard to claim ignorance. And when the investigators talked to him, they never asked him of how it is that you can be promoting an event and then when the bad thing happens at the event, claim that you didn't know anything about it. It just seems disingenuous to me.
Other discussion?
Mr. Chairman, I don't disagree with commentary. Just like these folks passed muster already once. And you've heard from the department that there has been no change in that status. I'm not sure why we're rehashing this. It kind of defeats the entire purpose of the pre-qualification process if we're going to then redeliberate something after they've already done, processed and gone through this onerous, situation here. So it's of some concern to me. They were up here for a license. They passed pre-qual. I'm not sure why we're saying what we're saying.
So if new information comes to light, we should ignore it.
She said there wasn't any.
That's what I just
Yeah.
asked, yeah, and we didn't, that wasn't given to us, or I didn't.
This was in our report, the new report, the THC Expo. That
But
was.
I
that
don't
was in
believe,
the
but I don't believe they were
charges
charged.
or,
They don't,
like,
they were
you know
not
what I mean?
charged
Like,
with
Right.
anything.
To me, it has to like,
Right. There was no charges issued, so.
Okay. Clerk, call the roll.
David LaMontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
yes.
Donald Bailey,
No.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 4 yeses, 1 no, motion passes.
6, applicant is Venco Michigan, Inc. Wishes of the board. Oh, I'm sorry.
Mr. Chairman, I move to grant Venco Inc., Venco Michigan Inc., state operating license and pre-qualification status.
Is there support?
Second,
There's moved and supported to grant license and pre-qualifications to Venco Michigan, Inc. Any discussion? Clerk, call the roll.
David Lamontagne,
No.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 4 yeses, 1 no, motion passes.
Okay, number 7, the applicant is Green Skies Far West LLC. Feeling of the board.
Mr. Chairman, I would vote to deny an application for, and actually, I think we have three applications here that are all related. We'll deal with them separately in motions, but there's 3 to talk about all at once here. It's the same information. And I would make a motion to deny.
Your support.
We have the statutory provision.
402 2C and 4023A, integrity, moral character, and reputation of the applicant.
Your support.
Second.
Moved and supported to deny. Discussion.
Mr. Chairman, I just, and perhaps I missed something in my notes here. Member Bailey, you're indicating that there was a disclosure issue? Is that in your 40? So the 4022C, maybe I missed something. I don't know. Chris, was there an issue with disclosure?
There was a traffic offense in 2017. There's no indication of exactly what that traffic offense was.
They're required to be statutorily disclosed?
No, and I think that was clear in there that it was not.
Well, if it's a misdemeanor or felon.
But I believe it was
There was
said in there that it wasn't.
There was an accident, and as a result of the accident, there was a traffic offense. Does not indicate that he was arrested, to my knowledge.
Any other discussion?
They called it an ordinance violation. So I don't,
Could be a misdemeanor or
Yeah,
a
it's-
civil infraction, either one.
But it wasn't documented, it wasn't stated in there.
correct, it was not.
Didn't we just decide a little while ago that we weren't going to go that route?
Based on assumptions, yes.
Any other?
I just,
Question.
yeah, I seconded for discussion, just. Clarify. And,
Right. Well,
And
the,
David, I concur with you. I don't recall any disclosure issues.
that might not be able to be used for amended or removed. I wanted a second for discussion.
Right.
For clarification, so I can remove my second.
Is there another support?
for 4023A,
Just to be clear,
Can we
Ms.
get a- we need
Cover,
a-
you're withdrawing your second?
Yep.
Thank you.
Correct. Their support? Hearing none, then motion fails. Now we need a motion to deal with it.
Mr. Chairman, I move that we grant Green Skies an operating license and pre-qualifications.
Is there support?
Second.
Okay, it's moved and supported to grant Green Skies Far West a pre-qual and a license. Discussion by the board.
Mr. Chairman, regarding this application, and it's the sole applicant. And the applicant here is 84 years old. My concern is we're starting to get into the areas in some of these where we may be looking at shadow owners, straw man owners. And I think that's a situation it's pretty ripe here. I don't know that we've addressed that through the investigation clearly enough. No one has ever spoken to the applicant to know this for sure. But what we do know in email exchanges is that the applicant is, as most people are at the age of 84, he's retired or at least semi-retired, and his son is operating his other businesses, which is completely reasonable. But now, at the age of 84, in retirement or semi-retirement, he's going to come out of retirement and operate at least 3, and I believe there's more applications to come in a highly regulated industry. That just doesn't seem genuine to me. And regarding the son who is taking care of some of these financial matters and running the business for his father, we find out that he has a conviction that would preclude him from getting the license in his name. And there's also, through the investigation that Laura did, there was some media accounts, social media posted by the son where he was claiming ownership of some of these entities. And I think we're getting into that straw man and a shadow owner that careful of, and we need to try to prevent when we can, when we see it.
Don, I guess we can all sit here and assume, so I would suggest that as a board, again, that we not assume, and then secondly, and probably more importantly, that we not discriminate in our messages around age as well. I don't think we can legally do that. So those are my 2 concerns, that the age, it's not for us to take that into consideration. And secondly, and most importantly, we can all assume as to what's going on, but I think we still need to stick to the facts of what's presented to us.
I think much of this is judgment, and I think we should exercise our judgment in these things. So I agree with you to a point. And as an 84-year-old, he could have as much vitality as a 40-year-old. We don't know that. We never talked to him. So and of course we didn't talk to him, but nobody from Laura sat down and talked to him. And maybe they would have found that out. We don't know.
But if we just look at all applicants, and this is probably for the department or the office, so we approve both a pre-qualification and a state operating license, and something changes that was presented to this board for those to be approved, of course, would be they come back before us, potential disciplinary, probation, suspension, revocation, correct? They go through that process?
Yes, that's absolutely correct. Once an applicant is licensed, then there are regular inspections that they'll be in and out. This is the first step of the phase, and we feel like we have done a sufficient investigation to allow the board to make a decision on the application.
Hey, clerk, call a roll
David Lamontagne,
Motion?
to approve.
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
No.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 4 yeses, 1 no, motion passes.
Okay, applicant Green Skies Hoover LLC number 8. Also for a pre-qual and a license. Board, what's your feelings?
Chairman, I'll make the motion with Green Skies Hoover LLC. Grant them application, pre-qualification, and operating license status.
Second.
Moved and supported to grant Green Sky Hoover pre-qual and a license. Discussion?
They do have pre-qualification status
Oh, they do? I'm
due
sorry.
to your previous vote.
Oh,
'Cause
gotcha.
These are the
So,
same
okay.
owners.
Okay, gotcha. Yep. Okay, go ahead and call the roll.
David LaMontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
No.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 4 yeses, 1 no. Motion passes.
Okay, number 9. I feel I'm in the wrong spot. Grant a license to Green Skies Healing Tree LLC.
I'll make a motion to approve the state operating license because they already have received pre-qualification under the Green Skies Far West. So it'd be Green Skies Healing Tree LLC, grant a state operating license.
Support.
Moved and supported to approve applicant Green Skies Healing Tree LLC. Discussion.
And I would just reiterate my point that based on what's presented, and if something changes, there's going to be due process. And I think it's a good public service announcement for all applicants. But same thing, if you didn't disclose, we've taken an approach there. So if something changes, then there'll be something will happen, but we assume that.
Okay, any other discussion? Clerk, call the roll.
David LaMontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
No.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 4 yeses, 1 no. Motion passes.
Okay, number 10, Precision Safety Innovation Laboratories, PBI PSI Labs. This is just for a license, correct?
Correct, for a safety compliance facility license.
Okay.
Mr. Chairman, I'll move to grant the PSI Labs LLC an application for a safety compliance facility license.
Second.
Moved and supported to approve PSI for a license. Discussion.
Chairman, I have one question. I believe it's, again, for Chris, and it's related to the same question we had for the other lab that was up. The technology plan, they're going to use a software vendor, Confidential Cannabis. And in the technology plan, it says that Confidential Cannabis is in the process of integrating with Metric.
My understanding, they have integrated. Don't they have integration?
Yeah.
Yes.
Also,
They have in other states as well. I
Yeah.
believe they've got integration.
and also, if the third-party integrator they choose to use does not happen to integrate with Metric, they can integrate with Metric directly.
These,
Yes.
all the licensees can?
Yes. Yes.
Yeah.
They
Okay.
can. Yeah. So they can go direct with.
Okay. All right, very good. That's the only question I had. Thank you.
Okay, any other discussion? Clerk, call the roll.
David LaMontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
I have a new name.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Okay, we need a motion to take off the table Iron Labs LLC.
Motion to go back to Iron Mountain LLC.
Is there support?
Second.
All in favor to take off the table Iron Labs LLC, say aye.
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 Opposed?
Yes, I'm opposed. I'm still.
Okay.
All right. Any board member now? We had, what is our motion now?
It's
Motion to
to,
approve.
It is a motion to approve?
it's to grant the license.
Okay. Do you have our answer?
Yes, Mr. Hannah called BFS. They have passed inspection. If, at this time, they don't have any flammables, therefore they have passed inspection. If they choose to get flammables, before they can do that, they will have to get a cabinet and have that inspected. But they are approved in their current state.
Thank you.
Makes sense.
Okay, any other discussion? Clerk, call the roll. Iron Labs approval?
David LaMontagne,
Yes.
Vivian Picard,
Yes.
Nicole Cover,
Yes.
Donald Bailey,
Yes.
Chairman Rick Johnson.
Yes.
Chairman Johnson, you have 5 yeses. Motion passes.
Okay, we're done with the licenses approvals. Down to number 8, department reports. Mr. Director. And we don't have a director.
He's coming.
Thank you, Mr. Chairman. As always, I have some updated numbers for the board's consideration in terms of application volume that's been received to this point. This says as of 8/3, which I think is last Friday, we've received 637 paid pre-qualification applications. In terms of license applications, we have 18 grower A, 4 grower B, 130 grower C, 44 processors, 137 provisioning centers, 8 secure transporters, 6 safety compliance facilities. The secure transporter, you may note, went down from 9. That wasn't a mistake. We actually had a withdrawn application. That's why they went down to 8. And we have 104 municipalities that have now, that we can confirm have adopted ordinances to opt in under the MMFLA. So in the last month, we did issue 2 bulletins. On 7/17, we issued one about the 30-day transition period, just trying to draw attention for licensees so they're prepared for when they achieve licensure that they have 30 days to enter all inventory into the statewide monitoring system, and some details around that. And on 7/23, we issued a bulletin regarding, this was produced by MIOSHA, regarding worker safety requirements. There's nothing adopted in the rules specific for worker safety because those standards already exist. So MIOSHA was nice enough to put together some of the standards that would apply to these types of facilities depending on the scope of their operation. So they're aware of what their requirements are there. Any questions on either of? Yes, sir.
Andrew, so secure transporter number continues to be of some concern to me. And I guess if you're one of the 8, that's cool. But, you know, I might have mentioned this before, and somebody in the audience a number of months ago talked about this notion of home delivery. And, you know, the approach, I think, has always been that this is about patient access and medicine, right? And if that's true, I'm not sure how come this hasn't come up before. I might have said something to somebody. I'm required by my healthcare provider to have my prescriptions delivered. And like, I can't go to the store, right? They gotta be home delivered. So not sure why this hasn't come up before. I'm bringing it up, not because I necessarily have any kind of particular interest. I just think it's of some concern to me that there's going to be 8 secure transporters. And it looks like to me that there's going to be secure transporters required at every step of this process. And I don't know where these people are going to come from. Perhaps there's more in the pipeline. I don't know. But I just want to tee up the conversation. You don't have to respond. I'm just kind of throwing it out there that, you know, perhaps at some point we're going to have to start thinking about how we are going to see to it that these patients continue to have access. So that's all I'm saying. No need to respond. It's a pleasure seeing you.
Can I respond? Okay. The only note I'd make that with secure transporters, there was a Public Act 10 that was passed in 2018 does clarify that secure transporters can travel through any municipality regardless of whether or not they've adopted an ordinance. So any licensee can operate statewide. So I don't know what the right number of them will be in terms of demand, but in theory, even a single transporter could scale up to serve the needs potentially between all the facilities. So
yeah, maybe it's not a problem. I don't know. I don't know.
But we do have others in the pipeline, so we'll continue to work on those. We do recognize only one's come through so far.
As I've been watching these different applications come through, it's dawned on me the other day, we have a lot of them, or a fair amount of them anyway, that only have one applicant as the owner or operator, whatever you want to call them. What happens if something happens to that operator? Licensee, I should say.
So they, the licensee, the ownership has to stay in place for that license to continue to be valid in that circumstance. So any changes in ownership have to be approved by the board. So I do think it's important for licensees with small ownership groups to consider what their plan would be in those circumstances, whether they need to, potentially take on other owners in order for the continuity of their operation.
That's why I'm bringing it up. I don't want us to get in the same place we got into with the non-disclosure stuff. Something that, heaven forbid nothing happens, but the reality is life goes on and things do happen. And I hope that the licensees are prepared to deal with that, however they have to deal with it.
Sure.
Okay, thanks. Anything else for the director?
I have other stuff too.
Oh, do you? Oh,
Yeah,
okay.
I was trying to stop. I was trying to stop after each category.
Mhm.
Just in terms of an overall program update, I want to reiterate some of the comments I made last time, more for the benefit of applicants and licensees to be considering, particularly for temporary operators, but for all applicants, how they will make the transition to becoming a licensed facility, the timing of that, the impact on current operation, to consider that and be prepared for that, inclusive of entering the inventory into Metric. If you're a temporary operator, you have to obtain tests for all the products, and that's the full scope of tests. So for example, if someone's operating a provisioning center that has a variety of products, all of those products then will have to go through all testing protocols before they can be sold upon achieving licensure. Also considering establishing business relationship with those other licensees. Specifically, I think the key points in the process are with safety compliance facilities as well as secure transporters. Once licenses are officially issued, you'll be able to go to our website and do a search on anyone that holds a license in any capacity. Also wanted to mention, when licenses are issued, along with the actual issuance of the license after collection of the regulatory assessment, notice will be sent to the primary owner with instructions on registering with Metric and designating their system administrator for Metric. That person will have to complete Metric training in order for that licensee to be issued an API key. So that's another consideration that has to occur before any other process can take place. The acquisition of tags, the tagging of product, the testing processes. So it's important for new licensees to be considering who that's going to be so they can quickly move through that process. Metric is already starting to schedule trainings for approved businesses. And one other thing, we are producing a safety compliance facility guide that accumulates all the rules and guidance that we've issued through the bulletins into one place. So anyone that's operating a safety compliance facility or interested in those testing standards will be putting something out that kind of captures all of that into one document. We've issued a lot of guidance regarding testing processes and the operations of safety compliance facilities, so we thought it was wise to consolidate that into one place. That's all I had.
Any other questions for the director? Thank you, sir. Appreciate
you.
it.
I just have a quick question under the system administrators for Metric. So in my line of work, we have a monitoring program as well, and we limit or we regulate who has access to that and who can feed into that. Is that going to be similar in this system? Or?
Correct. So we will reach out to the primary owner. So that's the person with the greatest share of interest, for them to be the one who communicates to Metric and assigns who their administrator is, and then they can assign roles to their employees, either directly in Metric or through their third-party system that communicates
with their own sign-on, and or like it's
Correct.
not delegated under like if I'm an owner, I can't use my sign-on and let Vivian input it. Just so if we start to see, because that could come before us too, they're not being honest in what they're putting in
Absolutely.
that system, and we have to be able to, just because I know it's another line of work that I do, but I'm telling you it happens, and we just have to know who's doing that, what they're accessing, all that.
Yeah, it's the responsibility of the licensee to determine access by their staff and control that access. So any bad information in that system is going to be investigated by the department, presented to the board for possible action, and the license is on the hook for
Correct.
any failures to report.
Facility license.
Correct.
Because that's really all we license.
Correct. Yep.
Director Briswell, regarding, we've taken a lot of criticism, every one of us, as far as how much time it's taking us on these applications, between Laura and the board. I know a lot of the criticism has been directed at the board for not approving enough of these, but we've addressed every application that's come in front of us that you've presented. Isn't that pretty much true?
Except one. One
We
is,
still have one pending?
yeah.
Oh, yeah, you're right, we do.
statement.
So all but one, everything that we've been presented, we have dealt with.
Correct, say that one, yes.
And there's been a number of issues, even in fact, some of the applications that we went through today. I don't remember which application it was, but there was a request for more information by the application section on July 6th for follow-up. And that follow-up came in on, today's the 9th, came in on August 7th. So the idea that we are, either the board or the application sections is the sole responsible party for any delay is not accurate. There's responsibility to go to everybody.
Certainly, and we continue to try and work and make our process more efficient. We implemented the program timely based on the statutory constraints and certainly had to do some learning as we went in defining the process. And some of that has involved, as applications were presented to the board, to some degree having to backtrack through applications to refine the process and ensure that you are getting the information that you requested to make decisions on the applications. Additionally, it has been a frustration with the timing on responses, and I think probably even more so than that, receiving complete information on the front end. I mentioned this at the last meeting that we put out the checklist on the supplemental documentation that was going to be required for the application, I think a month before we even published the first version of the application. And even going back to that, that hasn't substantively changed. And we still continually see applicants who don't submit W-2s and 1099s. They certainly don't disclose all of their bank statements. So they were routinely going back and issuing supplemental requests. And I think one thing applicants have to bear in mind is when we look at the volume of documentation that these analysts are reviewing, if they send a deficiency notice and then there's a response that's returned, depending on how long it's been since they've looked at that file, they don't have to refamiliarize themselves with the scope of hundreds, if not thousands of pages of documentation. So it's a challenging process, and we understand that applicants are doing their best in terms of trying to comply, but I think it's imperative that on the front end, they're looking at the checklist and the documentation being requested and ensuring that they're submitting it in as complete a fashion as is possible. That's not to say that there may not be some back and forth as we review the information and ask questions, but it certainly expedites the process if we have everything at our disposal. And as has been said multiple times, I can't emphasize enough making sure that there are adequate disclosures.
No one in the process, from the applications, from the enforcement, from the board, and certainly from the applicants, is going to say that there's not enough data collected. Everybody agrees in the process that there's an incredible amount of data that has to be gone through. And the quicker that it gets to the application section, the quicker it gets analyzed by the Chris's section, and the quicker it gets to us.
While you're standing there, I just want to thank you. This is a new board with a lot of challenges, and I think you're a great face for our state. I mean, you are under a lot of scrutiny, your whole staff. I don't think we get thanked a lot as the five of us sitting here, but I don't think the entire staff and I've had a lot of interactions with Laura and different, I don't think you're paid enough to deal with what you are dealing with. Sometimes I'm kidding. But
I'd entertain a motion.
Yeah. But and we don't get paid obviously either, but
Careful of those motions.
yeah,
You never
that's
know where they're going.
But I mean, all kidding aside, we're all here trying to do the right thing, and some of us are investing a lot of hours to do the right thing. And I think you're handling yourself and being very composed, even sometimes from us firing at you. You're getting it from all different directions. So I just wanted to take the time to say thank you, because we put you up against a lot, and so do the people in the audience as well. So thank you.
And also, I think you all would be astounded at the level of material that we get to review in terms of what the state actually puts together in response to the applications.
Well, these folks won't. They're the applicants. They know what they submitted.
No, but in terms of all of the checks and the background and all of that, the information that's presented to us for review is amazing. So they do a great job of putting the information together and also of summarizing it and organizing it. So thank you so much.
As long as I'm being thanked personally, I think a lot of it is owed. We do have a great staff. Brian and Chris and Colleen are all here, and Sarah Hernandez, who is our IT manager. They put in a tremendous amount of work. They do get paid, but also not enough, and certainly not for the hours that they're putting in, but we appreciate the recognition.
Okay.
Thank you.
5-minute break.
Anybody have anything to say? Hi, Mr. Lutz. How are you? Good. Nice to meet you. Heard a lot of nice things about you.
The other thing, we can't say, the other thing is we don't know.
I know a lot of, I know some 20-year-olds.
Yeah, exactly. For the record, I am not being paid to pronounce your Noted. I tried to clear it up. Not an attorney, but there's some things, when you work for a big corporation, you don't ever know anything you should. Right, right. Even if you're yes, 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 yes. I'm gonna relate it to quality or something. Right. I was like, well, that seems. Oh, right around.
What's your interest in mornings? Hey, you gotta put that one, right? That's what it is.
What just happened here?
public comment. I remind people speaking, try to keep it to 2 minutes. Try to keep your questions generic, not to possibly a license or something that the board could be acting on. So, with that said, the first one is Dan Nunez. Nunez, I'm sorry.
I'll also add, just as a reminder, that public comment is an opportunity to present your comments to the board for their consideration, not to necessarily engage in a dialogue or back and forth or have any questions that you have answered. Thank you.
The one thing, the request that I have, 15% of them.
Okay, thank you. Next is Eric Foster.
Good morning, board members and attendees. My question is in relationship to the state's efforts to help the banking community to start to work with the cannabis businesses. Following two aspects of federal guidelines, the BSA expectations for regarding marijuana related businesses from February 2014, and the FDIC statement on providing banking services from January 2015, and then the FinCEN guidelines on know your customer, SARS reporting, and monitoring procedures for existing accounts. Are there things that you as a board and Laura can do to encourage or incentivize banks to follow those specific aspects of federal advisory or guidelines that do allow for banks and credit unions to do business with cannabis related businesses, as is happening in Oregon, Washington, and other states, which would help as businesses are going through, especially the transition period for the Rule 19 operators, to have access to banking services during that transition period. Thank you.
Thank you. Nathan Schrick. Is that right, Nathan?
My name is Nathan Shevik. Good morning, everybody. I'd just like to speak to the board. They've tended to focus on failure to disclose and bad moral character for most, if not all, of their denials. Specifically regarding failure to disclose, there have been instances where a person has failed to disclose decades-old arrests or convictions. Today, I'd like to specifically address the misdemeanor convictions. Many applicants are forgetting to disclose old misdemeanor convictions due to the fact that they never realized they were misdemeanors to begin with. I would like the board to seriously consider and remember the fact that the vast majority of the public do not recognize or understand the difference between a moving violation, a civil infraction, and a misdemeanor when they are issued a ticket for a matter, particularly when their only required action is to pay a fine. Therefore, with regard to misdemeanor convictions, the board should not be penalizing an applicant for the general lack of knowledge and should not be taking these matters into consideration when evaluating an application, particularly when it is often the case that none of these misdemeanors are a basis for disqualification under the statute, and when the applicant could not have failed to disclose the fact that they never knew. Thank you.
Thank you. Paul Samways.
Good morning again. It's Paul Samways with Cannabis Accounting. I'm a CPA. I want to talk about, first of all, I want to thank Laura for looking a little harder at these previous operations, because we're finding things that you guys are going to see, like people making $30 to $50 million over the last 9 years in some of these municipalities. So I'm glad that you're able to see that and see who's paying taxes, because I think marijuana should be safe, legal, but taxed. And as long as people are paying taxes, they can use that money. Okay. And it's important, if you read that Safe Harbor banking book, you'll notice that 94% of the deposits that come from cannabis businesses goes right back out the door. And that's because they don't have access to any commercial lending at all from any federally insured institution. So I don't want to come off like an old man that yells at kids to get off their lawn. But, you know, if we don't get this right the first time, when are we going to have time to fix it? So the last thing I want to talk about is sales tax. Law is requiring that sales tax is being collected on marijuana sales since the emergency rules are in effect. There's nothing in the emergency rules that refers to sales tax. Laura does not have statutory or constitutional authority to levy sales tax or collect sales tax, but they're doing it in the lobby as a convenience to Treasury, because Treasury is the laziest department in the state of Michigan, next to Civil Service Commission. So, I mean, these guys are working hard, you know. So the point is, Mr. Brisboe has an email chain with the Director of Tax Policy at Treasury, went round and round and round. They did put out a revenue advisory bulletin, or an RAB, on sales tax in January. And if you read the footnotes, number 4 and 6, it clearly says provisioning centers under this or under the MMFLA, and then they give a MMA example where the patients have to pay the sales tax if they're registered primary caregiver. So if you look at cities like Kalkaska, Flint, Ypsilanti, you're only supposed to be selling to your registered patients anyway. So those facilities wouldn't have to pay sales tax, their patients would.
Thank you. Your time is
Thank
up.
you. Jackie Langworth?
Hello, thank you. My name is Jackie Langwith. I'm going to read a statement on behalf of Polichella and Associates. We appreciate the opportunity to comment on this nascent licensing process. We understand the Medical Marijuana Facility Licensing Act, the statute, gives the board the authority to conduct due diligence to determine an applicant's eligibility for a license. And this requires a certain amount of investigation, particularly with regards to an applicant's source of funds. However, Lara is asking questions and requesting information that are wholly unrelated to any statutory requirement and appear to have the goal of assuming nefarious intent from perfectly normal business transactions for the purpose of denying the application of an otherwise well-qualified applicant. The act states that the board may consider financial ability and experience, financial ability to purchase and maintain insurance, and the sources and total amount of capitalization. However, requiring explanation of bank transactions over $1,000 going back 3 years and asking for company and bank information for wholly unrelated non-marijuana business interests of the applicant go well beyond the scope of the statute and the board's authority and bear no relation to the scope of the elective financial criteria in the act. The financial due diligence investigation purpose is to determine whether or not a person is financially responsible and capable of running a business, not to attempt a forensic accounting of a person's financial history. This is concerning not only because it is not supported by the statute, but because it seems that Lara is actively looking for reasons to deny a license. The phrase integrity, moral character, and reputation is not a separate item on the elective list, but is to be considered in total with the personal and business probity, financial ability and experience, and responsibility or means to operate a marijuana facility. But the board has never looked beyond integrity and moral character and reputation. From those objectively viewing the board's action, again, it seems you're only looking for reasons to deny. We urge the board to consider that many of the applicants are non-lawyers who have been doing their very best to follow a rapidly changing, incredibly confusing set of developing laws over the past 10 years. They are entrepreneurs who are seeking to invest their wealth in Michigan to create a local economic growth and jobs. And they are all humans who have voluntarily subjected themselves to an exceedingly intrusive, long, and arduous and expensive process for the privilege of running a highly taxed, highly regulated business in the state of Michigan.
Thank you.
We respectfully request that you give them the opportunity to do that.
Thank you. Rick Thompson?
Hi, thank you. I'm Rick Thompson from the Board of Directors of Michigan Normal and MI Legalized, but today I'm just going to speak to you as one of those guys that pays $60 to the state every 2 years to get a license to use medical marijuana. Nothing happens in isolation. We're not complaining so much, I think, about the process by which y'all are approving applications. It's these every 3 months, kick the can down the road deadlines that come up again. And we've got another one in a month. September 15th looms like a dark cloud over all the positivity we've seen here today. We face another administratively initiated industry shutdown in less than a month, or about a month. The shutdown's dictated by legal phrases and financials, but what's really lost in this whole blind action are the people and the families affected by a shutdown. And again, that effect doesn't happen in isolation. September 15th is only 2 months before we face the general election. If you offend voters, some of them show up at the polls. If you inconvenience voters, more show up at the polls. But if you damage voters, they will all show up at the polls. The actions of the board and the MMFA rollout lie directly at the feet of Governor Rick Snyder. He's elected 3 of the board members. He selected Director Edgerton and Director Brisboe, who are both doing excellent jobs. If you remove the state's patient support industry from operation, the anger for those patients will fall upon the governor and the Republican Party he's the face of. And it won't just be those patients that are angry. It'll be their parents, their adult children, all the voters associated with them. Those entrenched conservative power players in Michigan should be aware of the electoral damage a September 15th shutdown will undoubtedly cause. I think Bill Schuette, all the down-ticket Republican candidates should take note. Half of the voters in Tuesday's primary voted Republican. Half of the ill people registered as patients are assumably Republican. That party will take a significant hit in the elections if the September 15th shutdown is allowed to take place. Now, I want that shutdown to stop for compassionate reasons. I want that shutdown to stop for logical reasons, and because the industry is not ready to absorb that kind of a hit. But if I have to push political buttons in order to get that September 15th shutdown stopped, then that's what the industry is willing to do. I'll also say, when we say things like there's distinct disadvantage provided to people who are not open, when people who are currently open under the emergency rules are considered, you indicate a bias in your approvals process that creates an actionable issue. That means you can be sued for it. The part of board members, your role in this is not to decide whether Laura's got enough information or whether people have lied to Laura. You're supposed to take the applications you're given and in an unbiased manner determine their validity. We're not seeing that happen today. When we complain about how somebody was allowed to operate for years in the city of Ann Arbor, what you're saying is that the Ann Arbor police didn't do their job, the Washtenaw County police didn't do their job, the Michigan State Police didn't do their job. You're not judge, jury, and executioner on those centers that operated in the gray market or under the emergency rules. You do a disservice to the program and to the situation when you comment like that. Thank you.
Devin Loker?
Thanks again. Just wanted to hit on a couple things, and it looked like we went the right way. When we're talking about the pre-qual part 1, it's about the individuals, their finances. Once we cover that, we've got them pre-qualled. We should be looking at only the building, the cameras, the part 2. I would hate to see a client come back for full licensure and have some, if it's a recently developed issue, that's fine. But if it's some outlier that was there and they passed mustard, I'd hate to see a reconciliation of prequels later in the process. Also, there was a statement about a caregiver operation that had made some money, and that was presumed to be inconsistent with the 2008 Act. I don't understand that. I think there was plenty of court decisions allowed these folks to be compensated for their time. If the law doesn't require statutorily the disclosure of traffic offenses, I understand the application very much reads that you would like that stuff, but there's very much a difference between what the law and the statute says and what the application requests. And so when you find that applicants are having a tough time reconciling whether or not they need to disclose certain offenses, a little more discretion would be advised. Thank you.
Jeffrey Hank?
Thank you, Mr. Chair. You look like you might be going golfing after this with that shirt on you're wearing underneath your jacket.
I got a combine I'm headed to.
I hope this doesn't take into my time,
Minute
but
and a half.
here we go. Sales tax, major disconnect with Treasury. Treasury used to tell these people they wouldn't collect the taxes. So, Mr. Bailey, everybody, you got to get Attorney General, Treasury on the same page. I've heard from Samways, multiple accountants, multiple lawyers, different opinions on whether temporary operators should be paying sales tax. There's arguments that this was a service, all these sorts of things, but there ought to be a uniform standard for that, and it probably ought to follow the Treasury memos that people have a reliance upon, particularly for these past operators. And if they try to pay taxes, it seems like they're kind of damned if they do, damned if they didn't. I fully encourage you to go after someone if they're a major crook, but some of these people are just trying to do the right thing. They're not necessarily up to bad, you know, they're getting bad advice from everybody, from the state, from lawyers, from accountants. Second thing, we got to extend the September 15th deadline, as has been mentioned. There's not enough patient access. Mr. Bailey, I was in your neck of the woods the other night in Traverse City. A little old lady got up at city council meeting and said, we don't have a single place around here. I don't believe there's been an operator approved up in northern Michigan. All across the state, people are looking for help and for access. So don't keep putting this arbitrary gun to their head on what's going to happen. On the policy, we need an extension to probably at least December, whenever we think we can get enough applications in. If there's 637 people who have filed, maybe 347 step twos, we've only gotten to a small fraction. Those people are trying to serve the market. So you can't say that a dozen people or even 24 people is an adequate market. It's just not. And I think you encourage, but well, you don't intend to, but you'll encourage the black market as a result of that. Lastly, and I'm not going to talk about an application. I oversaid this loud enough in the bathroom. I think Chair and Mr. LaMontagne heard me, but I've heard the Attorney General up here multiple times say, you can't talk about an applicant, and I'm not going to, and I know you guys don't want to go back and forth with questions because that's not how public comment works, but the United States Supreme Court has routinely, roundly rejected prior restraint. You cannot make content-based speech restrictions only for national security reasons. They are intolerable, and you can't do that, particularly when there's not a reciprocal right if applicants are being talked about up here in something that's not in the application. So I just ask you to get some policies perhaps that would help make this a little easier on everyone. And yes, it's a slow process. We're all frustrated and everybody's trying. I appreciate that too. This is tough, but it's taken 5 months to get a fingerprint notice. That shouldn't take that long. It should take a week or two after somebody files. So there is a back and forth. The point earlier was correct. An applicant has to produce more information. That takes time too, but I've seen people wait 5 or 6 months to get their first response from the department. So the best you can do to speed it up, and we really need it, and make this happen and help us out here. We're looking to you. This board has more of an ability to create jobs and help people than Bill Schuette or Gretchen Whitmer, who are going to pander to us for the next couple months. You're the job creators. You're the protectors of these patients. You really are. You 5 people have a lot of power. So use it wisely and use it for our public interest. Thank you.
I believe it's Benjamin Wrigley. Am I saying is that right? No. You got to learn to write.
Testing.
Better.
I want to address, first of all, it's Benham, but I want to address something that you said, Chairman Johnson, and I want to do it in the context of post-licensing. Now, I know we're looking ahead, but I'm looking ahead with all of our clients as to situations which I think we're all going to face. Number one is substitution. We have a situation that is where we have someone who's been licensed, multiple owners, and one of the she's has been diagnosed with stage 3. So we have a situation that's going to develop where I just want to make sure that the board understands that if there is a situation, a death, could be a male, could be a female, that does not automatically eliminate the applicant and the license. Now, what are we going to do about substitution? And this is more addressed to Colleen as well, as to the estate or the trust, which then steps into the shoes of the owner. Is there going to be a protocol can we establish as to come before you to discuss that? Because that would then, quote, be a change in ownership. It's no longer the individual, it's now the estate or the trust. The second will deal with additions, and I'm hoping we can develop some protocols as to it. As we move down the line, there are, and Ms. Picard spoke to this, about adding people in. I would like to see us be able to develop some protocols and some processes, application forms, whatever you're going to need to add people to these licensed entities. So I'm just asking that we begin to think about that as we move down the line. Thank you.
That concludes public comment. Down to, just before we adjourn, a note at the bottom says our next meeting is September 13th. That will not be on the 13th. That will be on September 10th. Same time, same place. Just make a note of that. It'll get published out, but.
Williams
What?
Williams building.
That's not what it says here.
Yeah.
Oh, okay. So that's wrong too. Williamson building.
I believe the meeting is being rescheduled to September 10th in the Williams Building, and there will be an official change sent out publicly.
Stand adjourned.
We need a motion to adjourn.
Mr. Chair,
In favor?
Mr. Chairman, I got one or two comments I'd like to make. In regarding the September 15th, we didn't make that decision. The board didn't make that decision. As many of the comments and many of the suggestions, you're directing them at us and things we don't have any control over. So we appreciate hearing them, but to think that we're going to have influence on some of the stuff, it's just not in our purview. And the nice thing about our caregiver system from the 2008 law is there's well over 270,000 patients. I'm sorry, patients and 43,000 caregivers. Those are year-old numbers. Those numbers are certainly up for both categories. So there is a process. It's not high and dry. It may not be as convenient as it was yesterday, but it's not pulling the rug out. It exists. The caregiver system is there, and that's something that everyone knew was coming. It did get pushed back a couple of times, but the caregiver system is still there to take care of everybody.
All in favor of adjournment, say aye.
Aye.
We're adjourned.
Thank you.
Hey, do you have parking things? Kelly, you have things for parking?